Good morning. I'm Jerry Dorn, managing shareholder of Anderson, Dorn & Rader. People often present to our office wanting to avoid probate, and we first need to define what is probate. Probate is the process of transferring title in the name of a decedent. When a person passes away and they own assets in their name that don't pass subject to a beneficiary designation or other non-probate transfer vehicle, the assets have to go through the probate process. A probate judge is the only person with authority to oversee the administration and disposition of those assets. The rules that apply differ depending upon whether a person dies without a will, which is what we call intestacy. If you die intestate, there is actually a structure of rules and statutes that govern the disposition of your estate, and they're based on the rules of consanguinity. Essentially, what happens is your estate is distributed to the persons who are in the closest degree of kinship to you. So if you have kids, it goes to your kids. If you don't have kids or other descendants, it goes up to your parents, and so on out the family tree. If you have a will, the will is presented to probate. The person who is named as the personal representative under the will petitions to have the will admitted to probate and to be appointed as the personal representative. Once that is done, the court will oversee the payment of creditor claims, if there are any creditors. The personal representative is responsible for submitting an inventory and appraisement of all of the assets of the trust. If the personal representative has to or wants to sell real property, they have to petition the court for confirmation of the sale of real property. The personal representative is responsible to notify the beneficiaries and keep them informed of the proceedings. And then ultimately, the probate judge will oversee the disposition of the assets to the persons who are legally entitled to them under the terms of the will. Now, it sounds pretty simple and straightforward, but there are some pretty major drawbacks with probate. Initially, it's a very expensive process. Not only do you have court costs, publication fees, but you also have personal representative fees and attorney's fees. Just as an example, if we take under the statute an estate of $500,000, and this is the gross value. So if there are any debts or if there's real property that is encumbered by a mortgage, we don't get to deduct that. It's the gross value of the estate. For a $500,000 estate, just in attorney's fees and personal representative fees alone, it's $24,150. That's approximately 5% of the value of the gross estate and doesn't take into consideration court fees and publication fees and other fees. Another drawback is that it's a time-consuming process. The typical probate takes anywhere from 9 months to a year to complete. So when beneficiaries contact us wondering when they're going to get their money, we tell them, be patient. It's going to take at least 9 months, maybe closer to a year, to get the money. Another problem with probate is that it's a public forum. Anyone who wants to go and view the file or sit in on the proceedings is going to be able to view your will. They're going to be able to view all of your assets. They're going to be identify who the beneficiaries of the estate are and what their addresses are. It's not uncommon if you're an inheritor or a beneficiary of an estate to get solicitations seeking to help assist you in investing your newfound wealth. So that can be problematic. Another problem with probate is if you own real estate in more than one state, you'll have to open multiple probates. Each state has exclusive jurisdiction in probating real property located within its borders. So that adds to the nature and complexity and the overall cost of the estate plan. There are numerous ways that you can avoid probate. The most commonly used strategy in our office is a revocable living trust. Ryan Stodmeister from our firm is going to be doing a brief video defining what a trust is and how it operates. You can also designate beneficiaries under the state's Transfer on Death Act. That's another way a simple way that you can avoid probate. But for those that are concerned about probate and want to learn more about how they can structure their estate plan and affairs to avoid it upon death, feel free to contact us. You can visit our website at www.probatebusters.com, or you can call us 775-823-9455.